Allahabad High Court this week ruled that the headscarf, hijab, that the Muslim women wear as a part of their Islamic tradition is a non-essential part of Islamic religion. And so, if a school, by way of imposing, prescribing a school uniform, tells the Muslim schoolgirls not to wear the hijab, they are not violating the essential religious tenets. And therefore, the school's policy founded on Article 14, equality, is not violative of the ladies' Article 19, freedom of speech and expression, Article 21, personal liberty, Article 25, freedom of conscience, freedom of religion. All these fundamental rights are not violated because the school's policy of uniform is founded on Article 14, and this particular aspect of the religion is non-essential. It is a troublesome classification of essential and non-essential. We can come back to that later. Now, what is this doctrine of essential religious practices? How did it come up? When did it come up? What was the case law? And what has been the case law since then? And where do we stand today? Now, in 1954, in the Shirur Mutt case, Honorable Supreme Court said that the freedom of religion under Article 25 does not protect all religious aspects, all aspects of religious tradition. Some are essential, some are non-essential, and the non-essential can be dispensed with where necessary. Which means there was Shirur Mutt, and it's a great big mutt. They had their faith, they also had their money and administration, and that they are located in Karnataka and also branched out. And those days Madras, today Tamil Nadu, made a law that the government could regulate the Shirur Mutt operations. The Shirur Mutt thought that Article 26 gave them the collective right to the religious denomination to regulate its operations. For example, to start religious and charitable institutions, acquire movable, immovable property, administer its own affairs without being hindered by the government regulation, all that. So Shirur Mutt goes to the Supreme Court, and Supreme Court told Shirur Mutt, sir, you have religious, you have secular aspects about your functioning. The religious aspects, leave them aside. The secular aspects the government can regulate. And also within your religion, the practice of the religion that you indulge in, some are essential, some are non-essential. Non-essential can be diluted. Essential, if they conflict with the constitutional principles and values and provisions, then they can also be diluted or set aside. So there is essential, there is non-essential. Non-essential is relatively easily, it can be set aside. Essential also can be set aside if they directly head-on conflict with the constitutional values. So very, very simply, if it is non-essential, according to the Honorable High Court or the Supreme Court, after going through the religious history, doctrine, their practices, ceremonies, rituals, customs and so on, they will come to an understanding, a position about what is essential, what is non-essential. It is a little ambiguous, a little fluid, but this is as it stands when simplified. Let me add more clarity. That was in 1954. You know, in 2018, the Honorable Supreme Court ruled that in the Sabarimala temple issue, women between 10 and 50 years were not allowed to go up the hill for any number of reasons. And the Honorable Supreme Court, the majority verdict was that it is antithetical to the religion. It is not an essential aspect of the religion. Therefore, Article 15, that is prohibition of discrimination, demands that you throw it open to all women. That is, again, excluding women of a certain age being declared non-essential and therefore set aside. That is Sabarimala. Then there is Anand Margis are there with bones and skulls. They would dance on the road, and the Honorable Supreme Court said that is not a part of Hinduism and therefore they have to drop the practice. Inessential, that is non-essential, so you drop it. You know, Christianity, there is another example. John Vallamattom, 2003. So, okay, Christianity tells you be charitable, donate. Donate, but donate as the government's rules expect you to. You can't say I'll donate in cash. You can't say I'll not register my property and I'll donate it. You have to have a registered property, and you have to have an official money, and that on a stamped paper, paying the stamp duty, subject to property rules, etc. You have to donate. So, how you donate is not a part of your religion. That you have to donate, be charitable and generous, philanthropic is a part of your religion. So, how you donate is non-essential. You can't claim that as a part of your religion. Non-essential can be regulated by the government. Similarly, go to Shayara, Bano 2017, the instant triple talaq. That's not a part of the Islamic religion. It's not a core part. It's not an essential part. Therefore, the Supreme Court struck down. There are other reasons as well. After all, it's a personal law. The courts don't strike down a personal law so easily because it was codified in the law related to the Sharia in 1937. The Honorable Supreme Court could find it easy to strike it down. Otherwise, what it would have done is a separate matter. Basically, what am I saying? Instant triple talaq is non-essential. Therefore, it could be set aside because it conflicts with other constitutional principles about equality, prohibition of discrimination, Article 15, etc. Now, within the Islamic religion, Honorable Supreme Court also ruled that cow slaughter is non-essential, therefore you set it aside. So I have given you Hindu examples, Sabarimala and Anand Margis. I have given you Christian example about charity. I have given you Muslim example about Shayara Bano 2017. I have talked about the current debate about hijab being non-essential and so on. Also remember, the same issue cropped up in Karnataka a few years back, and the Honorable High Court there also ruled the same. So there is a conflict between 14 and all those other articles, 15 and 19 and 25 and 26, etc. So that's one more example. So all these examples throw light on the doctrine of essential religious practices, which it emerged in the Shirur Mutt verdict of the Supreme Court 1954, and in many more verdicts it kept on showing up, and in all religions across the board. So that is about the doctrine of essential religious practices and non-essential. So that's it. So we'll go into the slides and one by one we'll see the details. Article 25. Curiously, Article 25 can go, I can claim Article 25, you can claim Article 25, we both could be in conflict with each other. I'll tell you how. Article 25 gives the people of the country freedom of conscience. That is, you can believe the way you like, in the system that you like, and in the religion of your choice. And you may even be an atheist, not believe in any of the religions. Now, this Article 25, the right to profess, practice, propagate the religion of your choice, or stay out of all religions. But this right is subject to all the fundamental rights in Part 3. For example, somebody has the freedom of speech and expression, and if your practice goes against that, that's a problem. Freedom of religion, freedom of business, Article 19(1)(g), and your religious rights. If they clash, that's a problem. If you exclude women, Article 15 clashes with you. Treat all the religions alike, Article 14 clashes with you. So, my point is, 25 is subject to other fundamental rights. 25 is also subject to public order, morality and health. That is 25. You know, I have the right to propagate, tell the greatness of my religion. You have the right to have your own religion. So I can't force you to convert into my religion by way of propagation. Right to convert is not available under right to propagate. So your 25 to have your religion, my 25 to have my religion and propagate it, they may clash. When they clash, the Supreme Court in the Stanislaus case 55 years back, 56 years back, so it ruled that right to convert is not a part of the right to propagate. That is as far as the 25 is concerned. 26, the same religious right is available collectively. We are a religious domination, a denomination or a religion, let's say a religious group. We have collective rights. We can acquire property, dispose of property, manage property and donate the property, establish charitable institutions, religious institutions like a temple or mosque, etc. That right we have got under Article 26, subject to public order, morality and health. But government also has the right to regulate the secular aspects, property, administration and so on. And if it is a non-essential aspect, for example, keeping out women as in the case of Sabarimala, then the courts also can strike it down. So 25 and 26, like other rights, they are not absolute. They are not unconditional. They are open to regulation because we have a constitution that requires certain values to be respected. So this is the comparative 25-26 comparative. This is very, very important for preliminary as well as main examination, the individual and the collective and how else they are different. So that's about 25-26 differentiation. Hijab, I told you about hijab. We are a pluralistic country. Hijab is a way of dressing. It is unharmful. It reflects the diversity which we should celebrate. And even the uniform policy of the school should be so accommodative because that makes the society resilient, coherent. Accommodation is equal to resilience and strength. But of late, the rulings have been that you have to adhere to the uniform policy of the schools and the colleges and your respective individual religious practices, where necessary, have to be compromised with. That's a ruling, but that has not been so always. It's of late only. But that's a ruling. So we have to accept a compromise somewhere so that the working of the society continues. So that's about the hijab. I talked about Sabarimala, talked about Anand Margis, talked about Shayara Bano, and in the Hanif Qureshi case, that was in 1958, cow slaughter was said to be non-essential and therefore you could not indulge in it as a part of your religious practice. Hanif Qureshi. John Vallamattom, I've told you about the Christian religious practice of charity. But the process of making a philanthropic gesture has to conform to the rules of the government of India or the state government. So, ERP doctrine is the essential religious practice and it's the Honorable High Court or Honorable Supreme Court that decides what is essential, what is non-essential, and accordingly how much of respect they command is set. Essential religious practice, Shirur, Mutt. I have already discussed it. Next. You know this doctrine of essential religious practice, it can go to a strange level also. We'll see that in the next slide. This we have discussed, Shirur Mutt. This we have discussed. The case law, Sabarimala we have done, Anand Margis we have seen, Shayara, Bano, Hanif Qureshi we have done, and Christianity, John Vallamattom we have seen. This is important. Ismael Faruqui, 1994. You know, the Honorable Supreme Court had the tough task of deciding whether, hold your breath, whether mosque is essential to Islam. See, Islam doesn't believe in idol worship. I go to a temple, there is an idol there. But in the mosque, there is no idol. And the people belonging to the Islamic religion, they can pray anywhere. We see them praying on the road also. So Islam not believing idol worship, what is the use, what is the purpose of mosque? Therefore, in this verdict, which is Ismael Faruqui 1994, Honorable Supreme Court said, mosque is not essential to Islam. So if it has to be acquired, the property, then it can be acquired because it is not essential. But then the Supreme Court qualified this general statement saying that if the mosque has a separate essential religious importance, for example, Jama Masjid of Delhi, that is a mosque but that has historical religious importance, that cannot be acquired. But in general, acquisition of a mosque by the government of a state or India, it should not be a problem because the mosque is not essential to the Islamic religion by virtue of the fact that in Islam, idol worship is not, they don't encourage. In fact, they are against idol worship. There is no idol in the mosque. So on that basis, the Supreme Court decided that mosque is not essential to Islam. That's a bit shocking, but if you understand the context, you will get the perspective. So, there we are about the current hijab case, Allahabad High Court, where the Muslim girls who go to school wearing hijab are told you have to conform to Article 14 based school uniform policy that establishes equality, which is vital for school administration. That's where it stands. I'm sure it will go to the Supreme Court. We'll see what the Honorable Supreme Court says. That's the essential religious practice, ERP doctrine. You get all that here. All the fundamental details and the moving details you will get here. Go through this book. Wish you all the best.